Good morning, everybody. I'm in a great dilemma because the presentation which I made overlaps with what Ruud has been talking about, and so admirably. I think if I'm going to show some of those slides which are going to be a repetition, I think all of you will get bored. And therefore, I use my lawyer's prerogative to talk extempore. And taking the clue from what Ruud has said, I thought I will develop a particular aspect of what he said. And I think if we can do that, probably we can make this session a little more interesting rather than he mentioned not once, many times, that IP is an asset. What is the true meaning of an asset in law? That which is valuable, that which is exclusive to you, that which can be exploited, and this which can have statutory and inherent rights. And if you look at the IP, an intangible property which has all the attributes of an asset, and then I want to draw a parallel between a tangible asset and intangible asset called your IPs. And if we can make a comparison and where the comparison converge and where the comparison diverges, I think that will be an interesting way of looking at things. If you don't mind, sir, I will take the clue from you. When you're talking about a tangible asset, unintangible, if you look at it, basically it all boils down to how do you create the asset, how do you document the asset, how do you get the title to the asset, how do you define the boundaries of an asset, how do you maintain an asset, how do you value the asset, how do you rent the asset, and how do you pay taxes on the revenues which you get out of these assets, and how do you live peacefully in that asset along with your neighbors who are friendly and not so friendly, and how do you acquire the new assets, not necessarily what has been created, and how do you comply with the competition law and various other antitrust laws which are prevalent in the same ecosystem in which you are living, and how do you handle the trespassers who come into your house without your permission? How do you throw them out, or how do you extract some monies from them for coming into this place? So if you look at this way, I think there are lots of parallels between what are known as the tangible asset which you acquire and intangible assets which you are now going to talk about. There are lots of parallels. Whether the IP in question, whether it is a patent or a trademark or a copyright or a geographical indications or any of those IP rights, most of it are statutory in nature. The creation, the title, and the enjoyment are all governed by the statutory rights. Many of them are not inherent rights. But there are certain assets which are not necessarily statutory, but which are sanctioned by the courts of law, by the common law principle, which gives you that asset. And if somebody steals from you, the courts will protect and prevent such stealing. So therefore, you have the IP asset which are statutory in nature and non-statutory. In the sense, non-statutory, what I'm talking about is not necessarily being of a statute law, but the judge-made law. Having said these type of parallels, but there are some fascinating things about the IP with regard to How many persons you can invite to your home for living as a tenant? One. If it is a hotel, maybe many. But can you create an asset where millions of people can live and then rent it out and then you can enjoy the rentals? Can you create an asset not for your own living, only for others to come and rent and use it? Can you divide this geographically and then say these guys can come, this guy cannot come, or I can have differential rates of rental from various things? These are certain fascinating aspects of intellectual property, and that gives you the freedom to exploit the intellectual property in the way in which you want to do it. Whenever you create an asset, unless you have a proper documentation and title, and tell the world, hey, this is my exclusivity, and don't come near here. This is the boundary wall which I am putting. And please don't trespass into this. The creation of those boundary walls and creation of the title to you is the most important document. And that is the one which ultimately gives you, whether it is a patent law or a copyright or a trademark. Having got this, how do you value it, or how do you nurture it? We heard fascinating stories from Philips. Excellent. We heard it earlier from my friend Vishwanathan sitting here. Oh, not here now. And also from you, sir, today. Fascinating. If you take a law firm, normally we think the law firms are basically to provide assistance to great companies like Philips or other multinational or local companies. But the law firm themselves will have good IP assets, which normally not very well known. The way you prepare a matter, the way you train a junior, the way you prepare an argument, the way you argue the cases, can be and will be an important intangible asset, and that is the brand value creation for a law firm. Instead of being an individual, if you can create about 300, 500, 3,000 attorneys who can think alike, act alike, and act in unison with certain basic fundamental principles, it itself is an asset. What we are now talking about is creation of an asset and nurturing it and increasing the brand value because of continuous innovations in what you do is what ultimately is going to create the value. Mighty capital of India, it attracted talents, it attracted various types of companies, work in this particular environment. Suddenly there has been a spurt of growth, and what you see, many of you today would have found extreme difficulties in negotiating in the roads because of the traffic. Yes, it is a problem because the city was not originally meant for handling these types of infrastructure. Suddenly it has happened. And the government is coping with their own problems of how to solve this type of issue. But because of something else happened, not because of you, the value of the property which you are living or you have acquired had become 100 times more than what you originally bought. It can actually happen in the case of intellectual properties also. What you thought as innovation, or what you thought as originally as an IP or an invention, which you thought it could be used only in a particular application, when it finds its application in multifarious ways, and when people start using it in a very different ways, and multitude of billions of people start using it, the value goes up tremendously. So therefore, we cannot say, hey, this does not have that much of value. I had an interesting discussion here, sir, about the accounting principles and how do you value the properties. I don't think anybody can say this value, this building, this Lalit Hotel is going to be, say, $100 million. If you ask 4 different accountants or valuers, I'm sure they will come with 4 different values, violently differing, and each one of them justifying what they have done is correct. Maybe they are right. So therefore, when you're talking about the value in law and also in accounting principle, there are three different terms used. One is the cost, other is the price, the third one is the value. And these differences are very different. Root was mentioned very clearly, there must be a cost of creation of a patent and the value should be much higher, then only it makes sense. Correct? So therefore, the cost of creation or cost of acquisition is one. They arrive at a particular price. But the real value of the property could be very different. For example, a pen used by my father, which I think he must have bought for 1 rupee, which was given to me as a birthday present long time back when he was alive, I cherish it. For me, it is invaluable value. For you, it is not even a 1 rupee value, even today. So therefore, if I want to sell it, I don't think I can give more than 2 rupees. But will I do it? For me, the value is immense. So the value is a relative term. To whom it is valued, who values it, and this value and the price and the cost, are they need to be necessarily a correlation or a correspondence? Answer, definitely no. Same thing happens in the case of IP assets. No difference. Cost of acquisition, cost of creation, and cost of sales, or the price at which we can sell or license it, or the value done by the valuation assessors, can be very different. But ultimately, as water finds its level, the price in the market also will fall. And ultimately, the prices are determined by the market forces of the demand and supply. That is the whole principles of economics. Nothing more and nothing less. Having said about the differences or the perception of the cost, price and value, let's now also talk about the recent developments with regard to the competition law versus your IP rights. When you are talking about IP as a business tool, when you have created a valuable assets, when you are exploiting that asset to your best of abilities, does any other law also impinge upon those rights? Is one of the important things which you must find. Let us look at this way. Every government in the world, any civilized government I would put it, would want the market competition to increase. When the competition increases, the general public benefits. This is the fundamental principle. If any barriers are created for this particular trade by way of horizontal agreements or vertical agreements, which will ultimately impinge upon the competition and thereby hurt the interest or the benefits of a consumer, the government will intervene and they will bring in acts like antitrust law or competition law. In any competition law, there would always an exception clause that this competition law would not affect the rights of an IP holder like a patent or trademark or copyright. So therefore, you feel there is exclusive domain where the IP rights holder can do what he likes and he can't be questioned by a competition authority saying that, hey, it is my rights, the law excludes me from operation and therefore I will enjoy what I do. Can they say? Today, if you look at the competition law, they are questioning, there is an area of intersection between the competition law as also in the IP law. The more and more you restrict the licensing conditions or other things with regard to exploitation of an IP, which in the eyes of a competition law says, hey, you are not doing fairly. There is a favoritism here. This actually infringes upon the competition law principles. And therefore, I want you to behave properly. And the various competition laws, they have started doing it now. So therefore, when you are in an ecosystem where we feel that we have exclusive right to exclusions or exploitations, which is granted, no doubt. But when you are doing so, you must also do fairly. You cannot have discrimination. You must have a way of doing things in a proper manner so that you don't get into a problem of competition law coming and knocking at your doors and saying what you're doing is unfair. It's very important now. Having created all, there is also an obligation on all of us, to be a true citizen, to pay the taxes. Whenever we talk about the taxes, we also always get jittery. An inventor who has created a valuable invention and has got an excellent patent on it, and when he exploits it by way of sale, assignment, or in the case of licensing, he gets revenues. And there are laws in very different countries that how that revenue needs to be taxed, how the royalty has to be taxed. And especially if the transaction is a transborder transaction, which country would have the right to collect the tax, which portion can be collected, what can be given as a set-off. These are other important aspects, because whenever you get revenues, revenue fellows also are after you. We don't want a situation where you got a Nobel Prize or one of the best medal in your company as the asset creator, and also taxman coming and say you're a tax dodger. We should not. So therefore, as a responsible corporate citizen, we also have a responsibility to comply with the tax laws. And therefore, there is another area where we have to be very careful, as when you are exploiting the IP values, there are also other obligations which you have to the society, as also to the other various laws of the country, wherever you are living or wherever you are exploiting, that those also need to be expected. Last but not least, how do you handle the trespassers? If somebody enters your house without a permission, you will throw him out. Are there situations similar in the case of IP? Answer is yes, and sometimes no. When do you say yes? Courts will, when you say somebody is coming in, you can always file infringement suit, ask him to get out from here. Definitely possible. But there are situations when the court will say, hey, hold on, you have created a wonderful asset, and this man wants to enter. If I evict him here, you are also not doing anything and exploiting it. You are not living in this house. This house is very big and very valuable in a very advantageous location, and people have to live here, and you are not allowing to do so. Therefore, why not I ask him to compulsorily live here and then pay a rent which I determine? And it does happen in many jurisdictions, where you created a patent and where you are not exploiting it, and where the public at large wants it, and where the licensing is not being done for considerable length of time, and where voluntary licenses are being asked for, and if it is not given on reasonable terms, sometimes the government, in the larger public interest, would step in and then say, hey guys, kindly give this as a license, and if you do not, then I will compulsorily invoke it. Now, when you're talking about these issues, what really happens is, while IP rights are given to you, which is a derogation of a normal principle of competition, giving an exclusivity which you can enjoy and exploit, it is also tempered with, why it is being given? There is public interest involved. If you are creating an invention, if I provide you exclusivity for 20 years to exploit it, either for your manufacturing or for licensing, etc., then you are rewarded for what you have done. So that is public interest. But there is a larger public interest of immediate requirement immediately, and if you are not complying with those things, the larger public interest will overtake the lesser public interest, and then the government will intervene. This is always a balance which always we have to understand in what ecosystem we are living in as far as IP assets are concerned. So, I would say that there are several ways we can compare the physical, tangible assets and intangible assets of IP. There are many, many commonalities. At the same time, there are many other facets for IP where you can exploit much more than what you could have exploited as a tangible asset. I think if you can make a comparison, and because over a period of time, people, last 300 years or 400 years, people have been used to dealing with tangible assets. Intangible assets is also a new commodity to deal with for judges, for people, etc. And if you can draw some parallel from there and draw the exception separately, probably we'll be able to measure, use, nurture, exploit, and prevent others from using their intangibles. I think I'll stop here because I am very keen to listen to other three speakers here. They're all eminent speakers here. And lawyers have a very bad habit. Once they are given a stage to argue on the mic, they don't know how to stop it. So I think I must learn when to stop. I think this time is good enough. And then we had an excellent presentation by Roon. And I am waiting to hear the others. Thank you very much. Good luck. Yes. Mm-hmm.
So are we talking about something like a framed obligation coming to India in perspective of licensing of patents?
Can you put the question again, sir? Last portion of the question. Can you?
Yeah, what I'm asking is, when you are saying that competition regulator is more inclined on fair licensing of patents, so are we talking about application of friend obligations that exist in US and other countries in India as well?
Yeah, of course, it will come. See, the Indian antitrust law is wide enough to include and implement these principles in India. And in fact, recently we are handling a very big matter in the competition law for an IP client. And this is coming very close to that. And I am not able to disclose the name at this point of time. Normally, people don't ask questions related to taxes for an IP lawyer. Thank you. Thank you.